I've got it on two.
Sir?
I've got it on two defendants with murder charges that are going to be pleased.
Okay, thank you.
This is the first one. This is the first one. The second one's going to be Cadrain.
Okay.
Mr. Reynolds is working on that. He's giving me a loop about what's going on.
Javiante Fontenot, what are we going to do on that?
I have a motion to withdraw that.
Okay, that's two cases. Darren Patterson,
That we'd ask that get a reset so I can try to get that settled. Just
How long?
Just a regular reset.
3 weeks going to be good?
Next week.
4 weeks good? Can we do 4?
We do.
All right. Darren Patterson, cause number 24, CR 1108. Mr. Burbank is the defense attorney, is requesting recess for 4 weeks in an attempt to resolve that. And Daniel Raleigh.
That's the state's motion, Judge. It has something to do with
Okay.
the state's radio.
Okay. And here is Chelsea Shipp. Does she need to be sworn in? All right, 22-40128 is called the state of Texas versus Chelsea Ann Marie Shipp.
No.
That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here?
Yes.
This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here now?
Yes, sir.
And it, I don't understand. So,
This is because of the writing, Judge?
yeah.
It's 40 years, Judge.
Yeah. Okay, I'm going to redo that, Jim. I know. I wish we had this pen for everybody. This pen seems to work better on the pad
Yes, sir.
than others.
Thank you.
And
Thank
God.
you for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years imprisonment. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have. How do you plead to this indictment, charging you with this first degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. Macon, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Shipp, you are pleading guilty to this first-degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here. to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God, out of States Exhibit 1, and the court supports those representations with positive findings that are in the record that state those admissions. I hereby find you guilty beyond a reasonable doubt of this first degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it? Is there any,
No, Your Honor.
nothing else from
No, sir.
anyone else?
Not today.
All right. Do you understand what has happened today, Nate?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Give Mr. Peterson to Mr. Patterson's file too.
There isn't any suggestion here that these reports are doctored up, but there's 4 separate reports which show alcohol in the defendant's system. That's what these reports represent, which concern the board that these scram reports reflect those series of tests.
I would ask.
That's back in. What was the most recent test failure? Was February 11th, right?
Right, Your Honor. And then he had a confirmed tamper on (2/27 of 2025) was the latest.
You're going to present evidence to support that one too?
Yes, Your Honor.
Here. Okay. When are you able to be ready for that?
I am able to be ready for that as early as Monday.
And these?
As early as Monday.
Okay.
Again, Judge, I would like to have sufficient time. If I could have a week after I receive the requested documents that I'm entitled to their file to look at.
You're entitled to discovery under the law.
Right. And I just need time to go through it, and then so if I could have a week after I receive the documents, Judge, I will be ready.
Okay. Here's what the court's going to do, though. This is enough evidence to me. This is sufficient information for me to modify terms and conditions of bond. You're not going to operate a motor vehicle.
He does not have a car. He is not operating. Family member had brought him back and forth. You don't even have a license, do you?
No, sir. See, but all of that I understand, but the problem is if these are true, that indicate that he's using alcohol, he's testing positive for alcohol. Point is how do we prevent him on other than his word? I don't drive and I'm not going to drive. How do we prevent him from jumping in a vehicle? And the second time he commits intoxication manslaughter, it'll be shame on me. Not on him.
Since he's made bond, Judge, I mean, besides that, he's complied.
But this is everything.
He contests those.
And and he can say, I don't drive, but how do you prevent somebody? How do you know that they are? Unless you're standing with them all day long. You don't know. It's just your word and your promise. But here, this indicates that you are not good for your promise if it's admitted, if it can be admitted. And that's all we have is your word. I don't have any other physical abilities to keep you from driving unless I throw you in jail, which I'm considering doing if this tests positive, because I can't control your actions if you don't follow the rules. I can't prevent you. No one can unless you are detained, because you can jump in a vehicle and we're going to do what we can to prevent that. The method that we've been using here, these scram devices, if these are admitted and properly, then that's going to be evidence that this court, which is enough evidence for this court to take some action.
Understood.
But I don't want anything bad happening in the meantime.
Well, Judge, he is still complying with the rules of the court in reference.
You mean like this, having like using the
Going back and
like
forth,
not using alcohol?
no, going back and forth to wherever he has to report to the scram, to give or change out the patch. And that is our position is that he has not ever been told that he's been tampering with anything, or that there were ever any problems with the people that he's communicating with.
Find out what the basis is. So
But he has timely reported to change out. He's complied with everything. As I said, he has not. And yes, you can walk outside and jump in a car and whatever, but he has, to my recollection, I represent to the court that he hasn't. But there have been no problems, but we can test those. And the person that we subpoenaed, Judge, and I guess I'm going to have to ask the clerk to maybe so we can issue it. Advised him that it wasn't his fault or there was a problem with it. It was environmental, and I think that's an issue. And I have it is in my subpoena that it should be in the court file. I formally requested a subpoena.
And you provided that information to the state?
Oh, good.
And who is that person?
It's in the subpoena.
Who? I mean, what's
Keep your subpoenas until they're actually served. They're not part of the court record.
No.
But you had to fill out what we sent it down to you.
I don't keep a copy. You get the originals back.
Hold on, I got file. No, it's
Same person. You have to think of it.
Okay. The only information I can see here is the state's Exhibit 1 that's part of this record, but it's a product of the Scram Systems Non-Compliance Report. Those series.
Can I show you? This is what I filed with the court judge, and it's a Mr. Simonette, Nick Simonette.
Okay. This was to be here on May 14th.
That was the last hearing.
Okay.
It was May 14th.
And
So
it's,
To get them.
but it just says Recovery Healthcare Corporation.
right, but in the bottom, I requested not only him, but for him to deliver his file with Mr. Rollins.
Well, but the court's orders are what they are. You can't operate a motor vehicle until further orders of the court, and you have to have an interlock device in any vehicle you attempt to operate. You understand?
Yes,
So
sir.
you got kind of two parts to that. don't operate. And if you even tried, you have to have an interlock device. And if you didn't, that'd be a second ground that would be a mistake. That would result in if this court found out about that, your bond would be revoked if there's truth to that. And you would just sit this one out in jail until we could resolve
Have
it.
you operated or tried to operate a motor vehicle?
No, sir.
But I don't, but once again, you're charged with irresponsibility in the operation of a motor vehicle by intoxication. This isn't going to happen on this. It's not going to happen a second time on this court's law. So you cannot operate any motor vehicle unless you have an interlock device. That's a condition of bond. Do you understand?
Yes, sir.
And you don't have to worry about it if you don't operate a motor vehicle.
I do not.
The other thing is that still the scram devices, we need to resolve that matter because this court trusts the scram device. As long as it's proven, well, there's no reason not to. My experience has been that they have been reliable. All right. What are we going to, when are we setting this for
You can
next?
just give, it can't be Monday, Judge, but if we could give them, and so
How much time?
I just need his reports for a couple of days to.
As soon as the court can send it.
2 weeks.
That's
2
fine.
weeks, please. Thank you.
And if the state gets a copy of their report, through which I'm entitled to, through their, we guess it's gonna be claimed,
Okay.
getting an expert,
Yeah.
you provided a copy.
All right. Sure. Let's get to the truth.
That's all I need.
What do we want?
Do you
Facts.
want to test them today?
Yeah, let's just do it just to be on the safe side.
I'll go take it out, go around over there, I'll wait.
25 CR 144 is now called the State of Texas versus Shelby Nicole Celerandi. She is here with Mr. Kindler, her attorney, and the state's attorney does the definitive formal reading of the indictment and arraignment here. We proceed in a summary.
She does, we make it.
In summary, this indictment alleges in paragraph 1 that on or about January 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWI convictions. In 2014, out of County Court at Law number 3, you were convicted twice. And paragraphs 1 and 2 constitute the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. You would be fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must serve 10 days confinement in the county jail as a condition of probation. Do you understand what the plan is, and is this your agreement that you've reached with the state?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those 2 prior DWIs in 2014, are those true and correct as they are alleged?
Yeah.
And are you pleading true and correct to this voluntarily and because it is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and passed.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've heard it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, made a part of the record without objection. And anything further, I'm going to follow this agreement. I will find then that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here, which supports your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You are placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation normal and customary for DWI type cases. You must serve 10 days confinement in the county jail. When can you begin that? Immediately?
Yes, sir.
And probation officer will prepare the probation order.
Let her know they may not.
There will be other conditions, including completing a DWI intervention class. That's good. You must have,
Voice on that.
as you probably heard from the previous case, an interlock device in any motor vehicle you operate.
Yes.
That you have to blow in. It has to. You have to pass the test, or else the ignition will not start the vehicle.
I have one right now.
Okay, we'll follow those terms and begin your probation successfully. Okay.
Thanks, sir.
She's here, Judge. That's the review on testimony and all.
Okay. I will take her next after this.
You not have that?
I don't have.
Okay, I wasn't sure. I mean, to be sure what was happening today.
At the conclusion of these pleas, there will be one allocution, Judge.
These were add-ons.
Yes, sir.
Okay.
These
I
are-
didn't
Mr.
recognize his name.
Mr. Perkins is on Monday's trial docket.
Not anymore then.
Correct, Judge.
We're going to call two cases, cause numbers 22-39766 and 22-39767. The state of Texas versus, is it Cadrain or Cadran? How do you pronounce your first name? Cadran
Yes, sir.
Perkins. And you are here with your attorney, Mr. Reynolds, and the state's attorney. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
He does, and you may.
Pleading to both?
Yeah, that's correct, Judge. Same amount of time to run concurrent.
In summary, these two cases, and we'll take them up together because they are similarly alleging the first degree felonies of murder in each case. And these state in 39766 on or about January 30th, 2022, and in 22-39767 on or about January 1st, 2022, both alleging in Jefferson County, Texas, that you committed the first degree felonies of murder by shooting the complainants or the victims in each case with a deadly weapon, namely a firearm. There is a second allegation of a prior conviction of robbery. Are we using that?
No, there's no need, Judge.
Okay. Do you understand, sir, what you're charged with in each of these cases?
Yes, sir.
These are first degree felonies, which means you face a term of life imprisonment if convicted, or any term not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached in your cases where you would be pleading guilty in each case, found guilty in each case, sentenced to 55 years imprisonment to run concurrently with each case. Is that your understanding of the agreement?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
I show you in each case what's marked as State's Exhibit 1. Did you sign those documents
Yes, sir.
voluntarily, knowingly, intelligently?
Yes, sir.
Did you discuss them with your attorney, and are the contents of these documents, State's Exhibit 1, all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each of these cases?
No objection.
Without objection, admitted. Among other things, these state that you are mentally competent to enter your guilty pleas. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you, or you've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. We're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is all of that true and correct?
Yes, sir.
States Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports are waived.
So wait.
Anything else to add by either party? I'm going to follow these agreements.
Sorry, Mr. Thomas.
The only
And
thing
fine.
is,
You, in each of these cases, you are pleading guilty, sir, voluntarily, knowingly, intelligently, to these allegations of the first degree felonies of murder in each case. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of these two first degree felonies of murder. I hereby find you guilty beyond a reasonable doubt of these first degree felonies of murders in each case. And I am following the agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 55 years on each case to run concurrently. There will be an affirmative finding in the judgments that a deadly weapon, namely a firearm, was used in the commission of these offenses. Do you understand, sir, what has happened today?
Yes, sir.
Anything else from the state? Is there anything?
we have an allocution from the victim's family on 39766, Judge.
All right. Go ahead.
Judge, he is in administrative segregation because he was contacting witnesses. And I think since that's no longer an issue, he's asking that the jail staff be allowed to determine where he stays instead of the court.
That's an accurate statement as to why he was moved into isolation. We had proven to the court that there were some threats against one of the witnesses that testified. Since we're not moving forward with a trial, I have no objections to the jail making administrative changes.
It is allowed, based upon no objection from the state. What do you have?
I have some family, Judge. I don't know where you want to situate.
Okay, the defendant can be seated right here in the witness chair. Thank you. All right, please, in each case, please identify yourself and how you are related to the victim in this case.
My name is Sabrina Matthews, Wagner Matthews. I'm Isaiah's oldest sister.
That's Isaiah Wagner.
Isaiah Wagner.
Who was the deceased, who was
Yes.
killed in
Yes,
this case.
sister.
Okay, go ahead.
Sandra Matthews, the baby sister.
Okay. All right, you may go forward when you're ready. Thank you.
Isaiah Brandon Wagner, a gentle giant, was taken from us on January the 30th, 2022. Our parents' lives are not the same since that day. My mom is 84, 666 since that day. There's nothing we can do or say to her to make it any better. We wrap our arms around her and tell her I literally love her every day. Mama, it's going to be okay. Deep down inside, she doesn't think so. And she doesn't feel it. My dad is 84. Your parents and family and friends can go and visit you anytime they get ready. What we have to go and visit is a grave site of Isaiah. As one of Isaiah's oldest sisters, like I stated, we're a very close-knit family. All five of us. It was 3 boys and 2 girls. Our nieces and nephews, we're all like this. We come together in times of trouble and talk to each other and pray with each other, comfort each other, encourage each other. That's all we can do. He leaves behind 2 precious little children that between me and my sister and other family members help raise those children. Our husbands, they're here today to support us. They have helped in ways they didn't even ask for. But the love that they have for Isaiah's kids, That's what they do. That's what we all do. Jerry, my brother that's here today, you will always be our big brother, even though I'm the oldest. He's going to always be my big brother. It took us a long time, but not too long, to find out after Isaiah had passed, the grave site where the grass was growing at. It didn't take us that long to figure out it was him that was going out there cleaning that up. You took our loved one. I truly wake up some days in disbelief. I can't believe it. I touch my, it's real. He's gone. He's never coming back. I have a picture of him on my fireplace mantle. I pass by that fireplace mantle and I say, Isaiah, you don't even know what hit you that day. You hunted him down like an animal. For what reason? Oh, they said it was a girl. Oh, they said you disrespected me. How so? A human being. What happened to just talking? What happened to let's just get together? When I was growing up, it was just, let's watch this. What happened to that? Take a life of another human and in that way. Coward, as a coward. How could you? So disrespectful on so many levels. I feel mad. I feel angry. I'm sad for my parents, most of all. I can't even imagine. I have 3 girls. I can't even imagine them dying and getting killed. Not dying just from a hospital stay or sickness. They had pneumonia and died. They had cancer and died. No. He was gunned down and shot and killed. Not one time, Kedron. Not one time. You shot him 41 times on Grand Street. Get my numbers right here. You shot him 41 times on Grand Street. As if that wasn't enough, not 1 week later, 50 shots was fired, and then the gun was unloaded on him. You got 55 years for that. 55 years. He's gone. My parents are dead. They won't see it. If my mama makes it, probably with her health, and I'm not being funny. If she lasts another, I hope so, 10 years, the way her health is right now, God is my witness. I have no reason to lie. I'm sworn in here before oath. Who does that, I say? Who does something like that? But a person who just does not care for another human. Today, I found out how many times he was shot, 41 times. I said that. How are you able to look at yourself for what you did? You will never forget what you have done for the rest of your life. You have a long road ahead of you to think about what you've done. So I say all of this to say this. You are a soul that Jesus died for. I believe that. I believe in there's a place after this life. I believe in God. God died for you. He died for me. Yeah, Isaiah made some mistakes. I'm not going to get up here and paint a picture of Isaiah, that Isaiah was all that in a bag of chips. I'm not going to do that. Isaiah made some mistakes. So have I. So have you. So I say this. You are a soul that Jesus died for. You need to repent. I am a soul and a child of God that Jesus loves, and I need to forgive you. So, Kedron Perkins, I forgive you for what you did to my brother. May your soul rest in peace.
There's this motion to revoke probation that's been pending since June, 3 years now, 2022, which was all about restitution. And there's a lot of money here. You were sentenced to 10 years in prison, probated for 10 years for theft. A motion to revoke probation was filed prior to the completion of your probation. That has been pending, and that tolls or keeps the probation open. And we do that in cases where people still have restitution owed. And in this case, as of May in 2022, you were owing $212,415 to the complainant in this matter, physician. And so that's what we do. From time to time, we come back and update the status on where you are to ensure that there's money being paid as ordered. The court's very sensitive to victims. I think every court ought to be sensitive to victims, but I am. I want to make sure that they're placed as close to whole as they were before they were victimized. So where are we on our loss here now?
Since
What did it start with? How much? Well, I want to get a basis line here. On the probation order, it was $265,137, and then it had been. It looks like 40 some odd thousand had been paid back over the 10 years.
like $75,360.
Is that right?
That's $75,860.
What's the balance now?
The balance right now is $197,640.40.
A little over $197,000. How much are you paying a month?
$50.
So what's probation office say? Anything we need to change on this?
So still marching since our last review was she had paid out $3,312 since November. Our last review, since our last review.
Yeah, but she pays $550 a month. Okay. So that's well.
It's all for restitution to restitution.
Ends up being about
To do something
$5,000 or $6,000
every year.
per year, which means at this rate you only have 33 years to go. Right now, in your financial status, is this the best you can pay?
Very best. Yes, sir.
Well, it's better than nothing here. Anything, other things we need to tinker with on this probation? She's not reporting probably anymore, right?
And she's I see her every other month.
Every other month, it's kind of just to check in to make sure that the restitution is being paid. Well, that's what it boils down to, the most important thing. So you were ordered, as all people are in this situation, to pay what you can. And the goal is to satisfy the restitution as ordered as quick as possible. But I think we all agree in this, understand in this case, it's going to take a while.
Yes, sir.
But keep plugging away. You get closer to the end. Anything else to add by the state?
No, Your Honor.
Okay. All right. From probation? Okay. Let's see her. Was it 6 months?
We supposed to be back here last month, but case moved to that.
Okay. Let's see her back in December, first part of December. Okay.
Yes.
Thank you. Please get her resetting. Anything else? No? We are in recess. Thank you.